On June 3rd, 2013, the United States Supreme Court decided a case which radically changed the approach of police in investigating traffic stops and being able to take buccal swabs. In Maryland versus King, the Supreme Court, in a 5-4 decision, decided that when a traffic stop occurs and somebody is taken into custody in connection with what is called a serious offense under the Maryland statute, and they dealt with murder, sexual assaults, etc., the arresting officer does not have to wait for conviction to take buccal swabs and does not have to have probable cause to take buccal swabs, but in fact, just based on the fact of the arrest, can take buccal or cheek swabs of the inside of the individual's cheek in order to get DNA. Justice Kennedy, in writing for the majority, decided that it clearly was a Fourth Amendment intrusion. In other words, that under normal circumstances you would need probable cause in order to take the swabs of DNA. However, Justice Kennedy balanced the need of law enforcement, according to him, for immediate identification with the rights of a defendant and the minimal intrusion, since we're not talking about sticking a needle in somebody, we're talking about merely sticking a Q-tip inside their mouth and not forcefully removing skin cells to be tested for DNA. Justice Scalia, leading a 4-member dissent, had serious critical issue with respect to the majority. Justice Scalia's position was the Fourth Amendment is clear and unequivocal, that you need probable cause in order to have any search under normal circumstances, and I can talk as a criminal defense lawyer as well as a law professor, under normal circumstances, if my client were in custody and the government wanted to take DNA to see whether or not he was connected to another case, they would have, until Monday, needed probable cause. They would have had to articulate facts for the judge, saying, here are the reasons that we believe that this person is connected with another case, and based on those reasons, we're requesting that you order a buccal swab. After Monday, that no longer needs to be done. After Monday, the United States Supreme Court decision says that without probable cause, as long as the person is in custody on a serious offense, and once they're arraigned, which may take a week or two, the state is free to take buccal swabs and then compare them to anything else in the world. They can put them into the National Bank of DNA, the CODIS Bank, to determine whether the individual matches the DNA of anybody else. One of Justice Scalia's criticisms of the majority is the majority seemed to indicate that DNA was taken in order to make an identification of the offender in custody. As Justice Scalia indicated in the dissent, there is a significant waiting period between the time that the buccal swabs are taken and the time the DNA is processed. He felt that the majority was absolutely disingenuous in saying it was used for purposes of identification. And it clearly was disingenuous. It's not used for identification. It's used to investigate whether or not the individual is connected with any other crime that might be contained in the CODIS base. Of interesting note locally is Tom Dart, the sheriff of Cook County, just announced on Tuesday that he intends on taking buccal swabs of all of the individuals in custody in the Cook County courts. Based on the new decision, he no longer needs probable cause. They're going to start with the more serious offenses, and then they can work their way down. And there's also been talk of introducing legislation in Illinois which would allow taking buccal swabs as anybody who is taken into custody in connection with arrestable offenses, not merely the serious arrestable offenses. So what will happen in the near future remains to be seen, but any of those following the Supreme Court take this as a serious incursion into what was previously the inviolate Fourth Amendment to the United States Constitution.